Chris Bishop.
Thank you very much, Mr Speaker. The Evidence Act 2006, sir, was a big step forward for the criminal law in New Zealand. And I was a law student in 2006. In fact, I was doing fourth-year law. I was doing fourth-year law at the time, and I did evidence law. And so it was interesting when I was doing that because the Act came in to force actually while I was a student, and so we had to sort of almost learn two bits of law. We had to learn the Evidence Act, which, as David Parker rightly pointed out earlier in the House, essentially codifies the common law rules. But we also had to learn some of the common law rules and some of the statutory provisions that overlapped with the common law. So it was an interesting time to consider evidence law, but it's a really important act, and the Honourable David Parker is very much correct to point out that it is of fundamental importance. And I was very fortunate to be taught by Associate Professor, I think she was at the time, Elizabeth MacDonald, and she has had some involvement, sir, actually in the Law Commission review that's led to this bill, and she's a very formidable figure. And so it's a very important act, and actually the process of the codification of evidence law in New Zealand actually started back in 1989, and like so many things we often deal with in this Parliament, Geoffrey Palmer can be linked to it because it was something that the Law Commission started to look at back in 1989, and the eventual outcome 17 years later was the Evidence Act. And it's of such importance that it's one of those acts where Parliament put in place a review mechanism so that every 5 years Parliament would consider or have the ability to consider, or at least the government would have the ability to consider whether or not the Act was working as intended. And so the amendment bill that we are dealing with today comes out of one of those reviews that the government commissioned in 2011, 5 years later upon the bill's passing, and now we have, and then the Law Commission did its review and published its report in 2013, and so we're dealing with the bill that results from that. And as has been pointed out by a member previously, the government actually adopted all bar one of the recommendations of the Law Commission. Sir, other members have gone through the bill in quite a high level of detail. Sir, I want to focus my remarks on the changes the bill makes to the sexual experience of complainants in sexual cases, because it's, I believe, an important change that the bill makes and something that I'm looking forward to examining in greater detail on the Justice and Electoral Committee, which, as my colleague John O'Naylor pointed out, is a good committee, operates in a fairly collegial fashion, much like the Regulations Review Committee does, that I was lauding only about an hour ago. So, sir, the issue of the admissibility of the sexual experience of complainants in sexual cases in New Zealand has, I think it's fair to say, a mixed history. And the traditional view, sir, was, of course, that the past sexual activity of complainants was relevant to the credibility of complainants, even where there was no relevance to the alleged offending. And so where consent was an issue in sexual cases, and it's so often the case in those sexual cases where consent is disputed, so where that happened, the defence would often argue that a complainant had consented because of past sexual encounters. And there are, sir, some horror stories of the way in which complainants on the stand were put through the ringer by defence counsel about their sexual reputation, which is now ruled out completely, or their past sexual encounter. So in some ways, sir, it was a form of propensity evidence. And as the Law Commission notes, sir, the common law gave considerable latitude to defence counsel and to the defence more generally in raising this as a form of defence and in raising it in evidence. So Parliament acted, sir, in 1977 through Section 23A of an amendment to the Evidence Act 1908 by passing, what is commonly referred to as rape shield legislation. That was initially only applied to rape, and then in 1985, sir, as part of the widespread reform of criminal justice statutes and evidence statutes, that was brought into all cases of a sexual nature, which I think, sir, is appropriate. And so that did place some limitations on what evidence could be applied to be admissible in those cases. So the evidence could only be admitted if it was relevant, and it could only be admitted if to exclude it would be contrary to the interests of justice. And Section 44, Sir, of the current Evidence Act essentially replicates that provision. So, Sir, what does this bill do? Now, there's a plausible argument, and one that I think some members have sympathy with, and I certainly do. There is a plausible argument that sexual history between complainants and defendants should be prohibited, should be absolutely prohibited. There is a plausible argument for that, Sir, and the debates go back and forth on that. And actually, it's true to say that New Zealand is one of the few jurisdictions where we allow it. So there is a plausible argument that it should be prohibited. But, Sir, I think the balance of opinion, and I think that I subscribe to this view, the balance of opinion is where the Law Commission came down, which is that where there are cases involving a prior relationship, those cases where consent is an issue will always turn on that belief in consent. And so inevitably, the prior relationship or the prior sexual relationship will inevitably be relevant to the question at issue in the case. So this bill doesn't prohibit sexual history evidence, but what it does do, Sir, is put in place some requirements that need to be fulfilled before an application can be made to offer that evidence in the case, Sir. So what it does is that it says that no application may be made to offer evidence or ask any question about the sexual experience of a complainant unless the party proposing to offer the evidence has complied with requirements set out in the Act. And the requirements are they must provide every other party with a written notice stating the party's intention to offer the evidence, the name of the person who will give the evidence, and the subject matter and the scope of the evidence. And, Sir, there's a series of other requirements which are laid out in the bill. And, Sir, this picks up on Elizabeth McDonald's and Yvette Tinsley's suggestion to the Law Commission review in 2011, which was reported back in 2013. It actually replicates, I think, Sir, the recommendation of the Australian Law Reform Commission. And I understand, Sir, that essentially what is being proposed in this bill has been in place in the state of Victoria in Australia since 2009. And I, for one, am really looking forward to perhaps hearing from some submitters at the Select Committee about the experience of that in Victoria and how that's actually worked in practice. They've had 6 years of that to see how it goes, and I'm really looking forward to hearing as to whether or not it's worked in Victoria and whether or not it's something that we should be replicating in New Zealand through this bill. Sir, the relevant pages from the Law Commission are page 138 in paragraph 7.33. In fact, the whole of that section in the Law Commission report is worthy of a read on this section, and as my colleague David Clendon made mention previously, it's a very worthy report. It's a lengthy document, quite technical in its scope, as I said at the start of my speech, but actually really, really important to the way in which criminal trials are conducted in this country. So, Sir, I support this bill. I certainly support it going to a Select Committee. The issue that I've canvassed in my speech today is one that Parliament has considered at various points. It's something that is contentious within the legal fraternity, but it's something that Parliament has to grapple with again. And I think the changes that are being promoted by the government through this bill will be a useful change to the law of evidence to make sure that victims or alleged victims, complainants in sexual cases, are treated with respect and treated with dignity, because that is everyone's right through the criminal justice system. And with those remarks, Sir, I commend this bill to the House.